case that I have no quick answers for. Any other easy questions? Yeah.
I'm just curious if you've ever worked with people at the other end of the continuum who were victims of a crime, and their observational skills were so good that they could work with a composite artist to come up with a drawing of the suspect that was released. Tips come in, and they are able to arrest the bad guy. And what it is about those people that they have, that they're such reliable witnesses.
I haven't. Clearly, people differ from one another in their overall ability to memorize things, and the degree to which people differ from one another is probably mediated by a lot of things. Their visual abilities, their ability to pay attention to what's eventually going to be important, the ability to focus on specific features of the person they're looking at that will most aid them in distinguishing that person from other people and or aiding a sketch artist, and all kinds of things. A person who is a portrait artist, for example, would be in a great position, assuming he or she had the inclination and ability to look at a face because they know. They'll be able to sort of verbalize themselves. The eyebrows will be this way, and the lips are such and such a thickness, and so on and so forth. So, all I can really say is that for whatever reason, some people are good. Now that said, in order for them to use whatever intrinsic abilities they have to memorize somebody's appearance and later help a sketch artist in putting together a sketch, some things have to be true. There has to be enough light. They have to be paying attention to the person's appearance. They have to be relatively close to them. I mean, all the things that I talked about apply to all human beings, no matter what their abilities are. So if somebody, let's say, had only seen a perpetrator under conditions of extreme darkness and yet produced a sketch that nailed to a T some particular suspect, I'd be not interested to say the least, but that's basically suspicious about how that sketch might have come about. But it couldn't have been based on the original memory that the witness had of the perpetrator's appearance. It must have been based on something else, some form of post-event information. What is it? Did they slip a picture of a suspect or what? I mean, you can't tell. It would be another interesting sort of situation, but one that would require a lot of sort of prowling around in the details to get a sense of what's really going on. Other
I want to say that I have a great memory, but your last slide, you said the title of your talk was "When Should Jurors Be Told About Human Memory and Perception?" And I had a different memory of the title of your talk.
Which you were probably right about, because originally it was "Why."
And it was the word "why." I brought my sheet, sure enough, I can confirm that it was "Why should jurors be told about human perception and memory?" And that actually is my question. It's to me an enormous difference between the two titles.
Yeah. Sherry asked me for a title, and I just sort of whipped one out. And then when I got serious about actually, making this talk, which was like maybe yesterday, I said to myself, that's not what the title should be. It's not, because there are plenty of cases that don't involve human perception and memory at all. Obviously, you're not going to want to provide a whole bunch of superfluous information to juries. The real question is when they ought to be told. I guess it could have said when and why. But basically, when, under what circumstances should juries be told about human perception and memory, which motivated, this law. They should be told about human perception and memory when there's a highly competent eyewitness who's identifying something important about what happened, like the person they believe was the perpetrator.
So are you relevant in all of those cases where there's a highly confident eyewitness? Are there cases in which you have a highly confident eyewitness where you're not relevant?
According to some judges, I'm not. Yes, there are plenty of those cases because I'm not telling the jury anything that isn't common sense. You're going to get up here and tell that you know, with better lighting, people remember better. The juries know that already. And so, you know, judges are convinced by people who don't want me to testify, typically prosecutors, that my testimony isn't relevant, shouldn't be provided. Juries can figure this out by themselves. Stuff like that. So, yeah. So no, not every case. Other questions?
I have one kind of final one. I know we're a little tiny bit over time already, but so would your recommendation be that there be legislation on a state-by-state basis about this? And if so, are there any states that currently have what you consider to be pretty ideal legislation?
Yeah, actually, some years ago, according to Atlantis, the state of New Jersey has done a very good job, in my view, in addressing these issues. In 2004, there's an edict that went out from the then state attorney general that provided, what in the view of people who study this stuff, very good suggestions for how lineup procedures should be conducted. Most important of which is that they should be conducted double blind. In other words, without the police officer who's administering the lineup knowing who the suspect is, which precludes any possibility that the witnesses, particularly the suspect, may be due to information provided inadvertently or advertently by the police officer. Anyway, so New Jersey did that like 8 years ago. Last year, there was a case that went to the New Jersey Supreme Court. And the opinion of the New Jersey Supreme Court came back just indicating that they were totally in tune with the relation between research in human perception and memory on the one hand, and aspects of the criminal justice system, those that I've been talking about, on the other. And the state of the court decision had a variety of suggestions for what should be done to preclude false identifications based on unreliable identifications. They did things like saying, well, there should be pre-trial suppression here, in which the nature of the eyewitness memory should be examined in detail, and the decision should be, judges should be relatively liberal in terms of suppressing identifications. They talked about having jury instructions that were very explicit in terms of describing how eyewitness testimony can be endured and so forth. So New Jersey has really been in the forefront of doing good things, having to do with bringing this information where it produces good in the criminal justice system. There are other states that have been sort of following along, North Carolina, Wisconsin, now in Minnesota. There's a lot of work being done on, what constitutes good and bad lines and so forth. So this is, I think that the DNA exoneration cases that began a couple of decades ago were pivotal in terms of alerting many people to the problems that are inherent in eyewitness identification. All right, well, thanks for staying an extra 10 minutes.